The clerk will open the court.
Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
We'll hear argument first this morning in 19605, Jim Olive Photography versus the University of Houston system from Harris County and the First Court of Appeals District.
May it please the court, Mr. McGovern will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal.
Good morning, Your Honors, and may it please the court. The Copyright Act grants Mr. Olive the exclusive right to use and authorize the use of his copyrighted work. It does not grant him a joint license with the government to use the work. It does not grant him a tenancy in common to use the work. And it does not grant him the right to use the work subject to a government easement. It granted him the exclusive right to use his work. The Court of Appeals erred because it failed to appreciate the precise property interests held by Mr. Olive. So if the court will just permit me a moment, I would like to start by briefly explaining the precise property interests granted by the Copyright Act and protected by the Takings Clause. And the reason I would like to do this is because if we do not get the property interest correct, we cannot accurately determine whether a taking has occurred in this case. There are two property interests that are important under the Copyright Act: exclusivity and transferability. Under Section 17 U.S.C. Section 106 grants Mr. Olive the exclusive right to use and to authorize the reproduction, distribution, and display of his work. This is an exclusive right not shared with the government. Now, the reason I keep emphasizing the word exclusive is because without the word exclusive, if you take the word exclusive out of the Copyright Act, you do not have a property interest. If this was in the real property context, we would be dealing with what would be a tragedy of the commons problem. Nobody has the exclusive right to use the copyright, so there is no property interests. So put differently, the exclusivity is the property interest that is granted by the Copyright Act. As the Supreme Court said in Keisner-Aetna versus United States, this is 444 U.S. 164 at 179 to 80. We hold that the right to exclude, so universally held to be a fundamental element of the property right, falls within the category of interests that the government cannot take without just compensation. So just as the government would owe just compensation if it took an easement on your real property, it owes just compensation if it takes an easement of your intellectual property. So while we're having our discussion today, I would like the court to remember this specific property interest. And every time you hear the word right, as in Mr. Olive did not lose his right to reproduce, Mr. Olive did not lose his right to display the work, I want you to stop and add the word exclusive in front of the word right. Because I think when you do that, the issues with respondent's case will be laid bare. Now, the second important interest.
Mr. McGovern, I'm just curious as to on that issue. Does the fact that he could have still sued, he still has the property in the sense that he has the photograph, and if someone other than the government were to do the same thing, he could sue them for damages, right? So what effect does that have on that?
That is absolutely correct, Justice Lehrman. And the thing is, the right to sue is not the core right granted by the Copyright Act. It's a procedural right that allows you to enforce the property interest. And the property interest, which is what the Takings Clause is concerned with, is the exclusive right to use and authorize the use of your photograph. And this goes back to the second important part about copyrights, which is that they are severable and they are transferable. Under Section 201D.
Mr. McGovern, before you move on that point, can Mr. Olive sue for an injunction to enjoin an individual and a corporation, government entity from using his property? And if so, with respect to a government entity, how is that a taking?
Well, you can sue, obviously you can sue a corporate entity under the Copyright Act and receive damages against a corporate entity. When it comes to a government entity, the issue is that the takings clause requires just compensation, not injunctive relief. And the law is clear that if there is a taking of the property, you're required to pay just compensation, even if it's a temporary taking of the property. So
it seems that the U.S. Supreme Court in Ex parte Young indicated injunction as being an appropriate remedy. I'm trying to reconcile how that fits into your argument.
Well, yes, Your Honor. So it is an appropriate remedy for copyright infringement under the Copyright Act, but a takings clause is a different claim than copyright infringement. And to the extent that there's a conflict, as respondents suggest in their brief, this is not something that the Supreme Court seems particularly concerned about. If you look at our brief at note 6, I believe, we have a citation to Florida Prepaid versus College Savings Bank, which says at note 9 that even though basically under the copyright, it says we're not concerned about the lack of a remedy here because you can sue under the takings. You can sue the state of Florida under the takings clause for the infringement of your patent. So to the extent that there's a conflict, I don't think the Supreme Court sees it this way. But even if there is a conflict here, that's not how you evaluate constitutional interests. You don't say a federal statute provides an injunction, therefore there's no constitutional interest. You start with the constitutional interest, see if there's a taking, and if there is, the remedies fall where they may, and you have to deal with that at that point. But you don't work backwards from a federal statute to a constitutional guarantee. But this comes back to the second point I was making, which is the transferability. Just because, and this actually goes to your point as well, Justice Guzman, just because there was an injunction and you have the right to enjoin the government from a future taking of your property, it doesn't remedy the fact that the property was taken. If the government comes onto your land and strip mines all of your minerals, and you show up and you show up 3 years later and say, "Where'd my minerals go?" You can't enjoin the past. The government's going to owe you just compensation for the taking of your minerals while you're on your property.
What if instead of strip mining the minerals, I own a piece of land and I discover that the government who is, building a highway nearby has been driving across a corner of my land for the last month. And so I call them and I say, "Why are your trucks driving across my land?" And they say, "Oh, I didn't realize we were driving across your land. Sorry, we'll take care." And they don't do it anymore.
Right.
Was that a taking of my land that's compensable under the authorities that construe the takings clause?
So it would be a violation of your property right, but it would not be a taking because
Okay. And so why is that different here?
Because the takings clause doesn't just require the violation of it doesn't just require the use and violation of the property right. There has to be an intent element. And this is an important point, actually. So even though the Court of Appeals didn't get into intent, and I don't think we should in this case, I do want to emphasize this point, which is that intent is really sort of the check on sort of blowing up the takings clause to mean more than it should. On the one hand, and it really strikes the right balance, because even the Court of Appeals said, we don't think it's right that the government is purposely taking your photograph and using it on their website. They should be paying you for that. We just don't think it's a claim. But and so nobody's sanctioning this action, and it is something that we don't want to do, and we don't want under the Constitution, because the takings clause says essentially we're not giving you.
My hypothetical is flawed because I didn't include an intent element. What if the government says, "Yeah, sorry, we knew that was your land, but it sure was a nice shortcut, and we were hoping you wouldn't notice. But sure, if you want us to stop, we'll stop." Mm-hmm. Now, would you have a takings claim based on the physical taking of your land because they drove over it and deprived you of the exclusive right to keep other people off of it for a period of time?
That is exactly right, Your Honor. So that is an easement over your land. If they intentionally take an easement on your real property, they owe compensation for the period of time during which they exercise that easement. This is United States.
Mr. McGovern?
Yes, Justice Bland.
Is there a property interest in a copyright arising under state law? In other words, Texas joined the Union some 40 years after the first Federal Copyright Act. And so where is the property interest that you're talking about that arises under state law?
Well, the property interest that arises under state law, I'm not sure about the answer to that, but copyright is generally, the interest is created by federal law, and this is a federally created property interest. And I think maybe what you're getting at is the statement that the Constitution doesn't create rights; those are created under other independent sources of law. And the federal government routinely creates independent copyrights. So this is a federal creation, such as a grant of a land lease by the federal government, or debts that are incurred by Congress, or copyrights or patents. The federal government is able to create property interests that are enforceable in state court under the takings clause.
But are they recognized as property interests in the sense of the takings clause, given that they're granted by the government and can be revoked under terms that the government sets? In other words, it's a franchise kind of an interest rather than a real property interest that arises under state law and could be enforced by state courts through the takings clause.
Well, as far as the idea that it's a franchise interest or some sort of a sort of a federal benefit as opposed to a property right, the court said in Horn the property rights aren't that easily manipulated. The Copyright Act itself states that copyrights are personal property and are private property. This is section 201D, which is where I was getting with the other part that's important about the text of the Copyright Act. Is that section 201 says that copyrights are personal property and they may be severed and transferred independently by means of conveyance, but they may be bequeathed, they may pass by intestate succession. So these aren't federal benefits. These are property rights recognized under state law as property rights.
Well, that's the piece I'm looking for, is the recognition under state law, because the federal copyright law is limited by the 11th Amendment and the ability to enforce it against a state actor. And that's why we're here. So there has to be some independent source of the right to enforce it under state law.
Well, the right to enforce a taking, well, I mean, a federal property interest would be recognized under state law as a property interest. But the 11th Amendment isn't an issue here because we're bringing a takings claim, which is sovereign immunity for which under the state of Texas is waived by the Texas Constitution under Article 1, Section 17, which allows you to bring takings claims. So it would be maybe I'm not understanding your question, but it seems to me that it would be a property interest that is created by, just because it's created by the federal government doesn't mean it's not a property interest.
No, but there are limits on that interest, correct? Like, for example, it expires after a certain period of time if it's not renewed. And there are limits to that grant of authority. And one of the limits is just by its very nature is that it's a federally created right. And so I'm trying to see if that is a reason that it can't be enforced in state courts.
No, I don't think that it is, because I haven't seen any case law anyway that says
against a state actor. I'm sorry, against a state actor.
Well, right. So I haven't seen any case law that says, I mean, so the 11th Amendment says we can't bring a claim under the Copyright Act for damages against the state for copyright infringement, but you can bring a claim against the state for the use of the property if it's done with intent and if it meets the other elements of a taking under the takings clause of the Constitution.
Counsel, could Congress just abolish the Copyright Act, or maybe a better example would be, could they say, look, a picture of the outdoors of a building, a picture of something that's in the public domain is not going to be protected anymore by the Copyright Act, and would that be a taking?
If it's referring to the idea that things that have not yet been copyrighted, then absolutely, the Congress can change the scheme of federal benefits as much as it wants. What it cannot do, and this is what Justice Story said in its commentaries, is that no state government can be presumed to possess the transcendental authority to take away vested rights of property. And this is a long established.
My question is, could Congress amend the Copyright Act such that this picture is no longer protected?
Not after the fact, Your Honor, no, they could not. That is a vested property interest. And this is Rice versus Minnesota, which goes back to 1861, that says it is a deeply established principle of law that, and it applies to federal, this might be answering Justice Bland's question as well, and it applies to federal property interests like grants of land and grants of franchises. These are things that cannot be taken away after the fact once they have been granted. And I say I only have 18 seconds left, so before I sit down for rebuttal, I would just like to remind the court where we started on here, which is that Mr. Olive has the exclusive right to the use and the authorization of the use of his work. And every time Mr. Kraft stands up and says he has a right, add the word exclusive in front of it. And I think that'll really help your analysis.
Any other questions? Thank you, Mr. McGovern. We'll hear from the respondent.
May it please the court, Mr. Kraft will present argument for respondent.
Thank you, Mr. Chief Justice, and may it please the court. Olive's takings claim is an attempted end run around the fact that there is no abrogation or waiver of sovereign immunity for the tort of copyright infringement. Now, there are several reasons to reject that attempt, but in my time today, I'll focus on two that are straightforward. First, the university's alleged copyright infringement lacks the essential elements of a per se taking. That is, there was no physical appropriation that caused Olive to lose its entire bundle of rights in any respect. And second, only authorized governmental acts can be a taking. Because the university lacked authority under Texas law to take Olive's copyright, this was at most a tort and not a taking. So for these reasons and the others presented in our merits brief, we ask that you affirm. So I'll start with the per se taking rule, which is the only kind of taking they're alleging here. And in the Horn case, the US Supreme Court described that rule this way. It is a physical appropriation of property that causes the owner to lose the entire bundle of property rights in the appropriated property. Now, we don't have any of that here. We don't have an appropriation.
Mr. Kraft, the US Supreme Court has said that you can have a takings claim for taking a trade secret. And if that's the case, would you have to destroy the trade secret entirely, in your view, in order to have a taking, or would it be enough if the government took the trade secret and started producing Coca-Cola, say, but didn't share that with the outside world so that Coca-Cola still had some value in its secret formula?
Yes, Justice Busby. So that's the Ruckelshaus case is the one you're referring to about trade secrets. And trade secrets are distinguishable in this respect. What you're talking about is the government compelled disclosure of a trade secret does in fact destroy that property interest entirely.
Well, not in my hypothetical, because they're not disclosing it to the world. They're just using it for their own personal gain. They're not disclosing it to third parties, much like Justice Lehrman's question in the opening, where there is still a value that the trade secret owner can get from using it because the government hasn't shared it with the world. They're just also using it. So would that not be a taking in your view?
But in the Ruckelshaus case, the court said it would be a destruction because even if it's just the government using it, it is no longer a secret, and therefore the property right is distinguished. But that doesn't happen with copyright and the exclusivity that Mr. McGovern was talking about. I think the simple answer to his line of reasoning about exclusivity is that yes, the Copyright Act does confer exclusive rights on the copyright holder, but a violation of those rights does not mean that those rights are destroyed. And that's
plain. Do they have to be destroyed under the Texas Constitution? Because our takings clause is worded differently. It says taking, damaging, or destruction, or appropriation to public use. So would this be, did they appropriate Mr. Olive's photograph to public use?
That is their claim, Justice Busby, that it was appropriate for public use. And I understand that the Texas clause is worded differently, but they have been interpreted to essentially be the same. And to the extent there's some added language about damaging property, that's not the claim they're making in this case. And that would not work for a per se taking, which is the only kind of taking they've claimed. It has to be a physical appropriation of the property.
Well,
and
if
they're
that were the
saying,
case, they could be allowed to replead, right?
no, Your Honor, they should not be allowed to replead to state anything other than a per se taking, because they already had a bite at that apple. In the Court of Appeals, in our opening brief, we initially said you should analyze this case under the balancing test and under the three factors that are considered in most takings cases. They responded to that by saying, oh no, that test is the wrong test. This is only a per se taking. And that is the only correct analysis that should be applied here. So in our judgment, they have affirmatively waived any argument that this is anything but a per se taking. And therefore, they're
under your argument, it's in which a per se taking can only occur if the government's action completely destroys the entire bundle of rights. Then I would think that you would have to disagree with your opposing counsel's answer to my hypothetical about the government driving its intentionally driving its trucks over a corner of my land. That could not be a taking because they've not completely destroyed the entire bundle of my rights.
Well, to be clear, Justice Boyd, it does have to be an appropriation, a taking away or destruction of the entire bundle of rights, but it can be in just the part that was appropriated. So if I could give a twist on your hypothetical, if they came along and said, we're going to take a corner of your land and erect a porta potty for the construction workers on that spot, then you would lose your entire bundle of property rights in that parcel of your land. That could be a per se taking. But your original hypothetical was just talking about a trespass. And what we know from the per se rule from the Loretto and the Horn cases is that a per se taking has to be a physical occupation of the property. It has to be a physical appropriation in which you lose your entire bundle of rights in the part that was taken. That doesn't happen in your trespass hypothetical, Justice.
I thought Justice Boyd's was more in the nature of an easement. So is your view that you can't have a taking of a non-exclusive easement?
You can, Justice Busby. I think we'd have to get into what exactly the facts were in this hypothetical. I mean, if it was frequent enough to constitute an easement as opposed to a trespass, then yes, I think you could have a per se taking of an easement. That's in fact the United States versus Cosby case that's cited in the Loretto decision with the.
But that would not be a complete deprivation of the entire bundle of the owner's rights. So how could it be a taking?
I'm sorry, Justice Boyd. I mean, what we look at is if there's a complete deprivation in the part that is appropriated. That's what a per se taking is, if you're talking about part of the property.
Right, but how could a taking of an easement ever be a taking? Because an easement never completely deprives the owner of the entire bundle of the owner's rights.
I think it would be viewed under the Cosby case, it would be viewed as a taking of your entire bundle of rights in that what the easement is. It would be taking away your entire bundle in that interest. But going back to the per se taking rule, a mere violation of Olive's exclusive rights under the Copyright Act does not destroy those rights, and that's plain from the text and the structure of the act, as well as Supreme Court precedent. Let's start with the text.
Excuse me, Mr. Kraft, but if now this photograph is just in the public domain and anyone can now use it and reproduce it for whatever purposes, then hasn't he lost everything as far as the value of that?
He has not lost everything, Justice Lehrman. And my first response to your question is, you're talking about how widespread is this. I mean, your hypothetical is if it's in the public domain, if it's
or just the fact that, let's say, the university has put it in a brochure or put it on their website or whatever, and then, you know, X person, third party, whomever could also then copy that and use it in that sense, right?
So in the per se taking rule, we don't get into the question of how bad is it? How severe is the intrusion? That's what we do under the balancing test.
No, I'm just looking at the fact of whether or not his entire bundle of sticks has been taken from him because of that.
And the answer to that is no, Justice Lehrman. And maybe rather than just go through the metaphor of bundles and sticks, it would be helpful, if you'll bear with me, if I just ran down all the rights that Olive still had during this alleged infringement by the university. Under Section 106, he still had the right to make copies and distribute them, to make derivative works, to display the photograph publicly, to license other people to do all those things. And because those rights were exclusive, he also had, as Mr. McGovern said under the Kaiser Aetna case, he had the right to exclude anyone from doing those things, including the university, through a suit for injunctive relief.
But what is the market going to be if anybody can just take it and use it now? Those are just words. The reality, there has to be a market for it.
Justice Lehrman, in a per se taking, we don't look at the market value of.
No, I'm not talking about value. I'm just talking about marketability, period.
Or we don't look at the marketability either. For a per se taking, the question is, was there a physical appropriation of the entire bundle of property rights? And if there's not, then there's not a per se taking. If there is, then the things you're talking about, like the diminished value, the diminished marketability, all that just goes to damages. First, we have to get through this hurdle of, was there a per se taking? And that requires a physical
really
appropriation.
A per se taking, though, Mr. Kraft? I mean, are there cases that say that per se versus regulatory takings is the right framework even for intangible property rights? I mean, that some of the language in Horn seems to suggest that the court is looking at whether there's direct appropriation or use in the context of an intangible property right. So what cases tell us that per se versus regulatory is even the right framework for intangible rights?
Your Honor, the per se taking rule is a limited exception that was carved out in Loretto and reaffirmed in Horn for physical occupation. So anything else, including an intangible right, has to be under the balancing test. Ruckelshaus deals with an intangible property interest, and that was analyzed under the balancing test. There is no case that says that an intangible property right can be subject to the per se rule. I think the language you're referring to in Horn is the quotation of the James versus Campbell dicta. But there, the court was simply citing that dicta for the proposition that the per se rule applies to real and personal property. It did not have occasion to address whether a use of an intangible property right would fall within the per se rule. We simply don't have a case that says that. So all we are left with.
What about the amicus cases that they cite, going back to Justice Story and to that area that you can have, that suggests that you can have an appropriation of an intangible property right?
So if I think you're referring to the patent cases, and a major problem with all those cases is that for the 19th century and really into the 20th century, those cases were not deemed to be under the Fifth Amendment. They were not deemed to be takings cases. They were based on an implied contract with the government. So it was really a contract claim, not a takings claim. So we don't have a case where, I mean, once the per se rule evolved, we don't have a case where there is a per se taking of an intangible property right. I mean, presumably they would have cited one if they had been able to find one. So what we're left with is these precise parameters of the per se rule that have been sketched out in Loretto and Horn, and this copyright infringement claim just doesn't fit within those.
Mr. Kraft, I'm looking for a limiting principle here. Suppose the university just felt sorry for the students because of the economic hardships they were under and just copied all the textbooks they were going to use and passed them out to them rather than have them be purchased, just passed them out for free. Taking there?
Well, first of all, Your Honor, that would be a copyright infringement. So that would
we've got one here.
Right, but it would not be a per se taking. So if you're looking for a limited principle, I think they have limited this case to a per se taking. In your hypothetical, perhaps somebody could say that the infringement, if we assume, and this is a matter in dispute in this case, if we assume that a copyright is property subject to the takings clause, if you assume that, then if you're claiming a copyright infringement rose to the level of a taking, you'd have to do that under the balancing test. So if you decide this case, if you disagree with us that copyright is not an interest protected by the takings clause, or if you assume without deciding that copyright is protected by the takings clause, then what we're left with is this question of, was this a per se taking? And if you decide, no, it was not a per se taking, that would still leave an open question as to whether infringement could be a taking under the general balancing test. But they've confined themselves to a per se taking, and copyright infringement just doesn't fit. In my remaining time, I did want to touch on the other point I wanted to discuss today, which is that under settled precedent from this court and the United States Supreme Court, a taking must be an authorized act. That goes back to this court's decision in State versus Hale from 1941. There, the court said, the liability of the state under Section 17 of Article 1, where the authority is properly exercised, should not be confused with the claim for damages caused by the negligent acts or wrongs committed by its agents or officers. In the first class, the taking is done for the state in the exercise of lawful authority. And federal law is the same. And Judge Easterbrook summed up the Supreme Court precedent this way in the Chicago-Milwaukee Railroad case cited in our brief. Authorized acts of the government may be takings. Unauthorized or mistaken ones are torts for which the officer alone is immune. Here we have
I think that's why we said in Gregg that you have to have a specific act, know that a specific act is going to cause identifiable harm or that it's substantially certain to result. But why isn't that met where, I take it that the University of Houston had the authority to make a website and to put things on it. And certainly that was done for public use by promoting the university. But why isn't taking something at least as alleged and removing the copyright from it and putting it on the website, why isn't that an act, specific act that is going to cause identifiable harm?
Well, first of all, I do want to be clear about what's in this record. And there's been some talk in the briefs about the university downloading this image from Olive's website. That's not in the live pleading. There's nothing in the live pleading that says how this came to be in the university's possession in the first place. But to your point, the problem with the authorization requirement here is that we have a direct limitation from the legislature that says University of Houston your eminent domain authority is limited to land, and not just land, but land in only certain counties, Victoria County and Harris County and surrounding counties. So when we have that direct limitation from the legislature, even if you're doing something within the scope of your duties, as you described, creating a website, if you're violating that direct legislative restriction, then it's ultra vires, and it cannot be a taking if it's an ultra vires act. It can
So in
only be a
Bragg
tort.
with the flooding, if the flooding had occurred outside the area where they had eminent domain authority, there would be no taking.
Well, I mean, I would have to look at the facts of that case.
Geographically limited and the flooding went outside that area, you would say that people outside that area are just out of luck.
If there is a direct legislative restriction on their authority to take, then yes, that would just fall under, a negligent act. It would not be a taking because it would not be an authorized act. And I would just close by saying, they briefed this at the petition stage and in their opening brief. They now say you should send it back. There's no reason to do that. This authorization issue is a pure question of law. It's an alternative ground to affirm.
Any other questions? Thank you, Mr. Kraft. Mr. McGovern, I believe you, excuse me, I believe you have 5 minutes.
So let me get the camera right, make sure it's. All right, thank you, Your Honors. Just a few quick points in rebuttal. To begin with all due respect to Mr. Kraft, they have the takings rule exactly backwards. The per se takings rule is not an exception to the regulatory takings rule. The per se takings rule is the takings rule, and the regulatory exceptions came up in the 1920s and 1930s when they realized that there were certain regulations that were just going too far. As the Supreme Court has said in Tahoe Sierra, our jurisprudence involving condemnations and physical takings is as old as the Republic, and for the most part, involves the straightforward application of per se rules. And a regulatory takings jurisprudence, by contrast, is of a more recent vintage, characterized by essentially ad hoc factual inquiries. And the inverse condemnation rule is simple. When the government physically takes possession of an interest in property for some public use, it has a categorical duty to pay just compensation. Now, my opponent made a lot of the term physical, but that is a far, far too literal reading of what the per se takings rule is. Even in Loretto, it doesn't say that it has to be tangibly, physically touched. It says that you have a per se taking when the taking is categorized as a physical taking, when it can be described as akin to a physical taking. So that's why you have United States versus Cosby, where airplanes flying over a piece of property was considered a taking. And Justice Busby was exactly right. When you're talking about intangible property, the question isn't, was it a physical taking? It's whether there was a direct appropriation of the property. And this comes straight from Horn again, which says that, specifically in the context of patents, the patents may not be appropriated or used without just compensation, which mimics perfectly the clause of the Texas Constitution, which says that the property may not be taken, damaged, or destroyed, or applied to public use without adequate compensation. It's use. They don't have to actually physically control the piece of property, which makes sense in the context of a takings of intellectual property, because the right protected, the specific property interest protected by a copyright, is the exclusive right to use. It's just like if you had a piece of property, you have the exclusive use and enjoyment of your land. If the government takes an easement across your property, you've lost your exclusivity. And that's the analogy I think that best fits for how the takings clause applies to intellectual property. And to just touch briefly to go back to the question Justice Bland asked me before the break, there are other types of federal property that would be considered protected under Texas law, such as federal currency or treasury bonds. If the state of Texas came and took all of my treasury bonds, the fact that they're federal property wouldn't stop that from being a taking under both federal and Texas law. And I would just like to close by pointing out then when Mr. Kraft gave you the list of rights that are protected by the takings clause, he did precisely what I said. He talked about the right to reproduce, the right to distribute, the right to display. But it's the exclusive right. It's the exclusivity that under Kaiser Aetna is the core fundamental property right that is protected by the Just Compensation Clause and the Fifth Amendment. And so,
what's your response to the no authority argument?
I'm sorry, Your Honor?
What's your response to the no authority argument?
The no authority for?
To take the photograph.
Oh, well, and that is, sorry, 1 second. That is, that's covered by the court's decision in Cook, which basically said that the intent to take is clear from the fact of the physical taking. But it would also be the idea that you have to authorize a taking. That doesn't appear anywhere in the takings jurisprudence. That is they are basically globbing on to the contract situation where when the state is acting akin to a normal person and acting under color of contract right, they don't have to they don't have a taking there because you have to show more intent. When the state actually comes and takes your property, that is a physical direct appropriation of your property. And that's what's happened. And that's what happened here. So just to conclude.
Counsel, does it matter with respect to this question of intent, does it matter that the way that this copyright was infringed was exactly the same way that any private actor would infringe the copyright? Whereas traditionally in the takings context, you'd be dealing with the government acting in its sovereign capacity to take property in a way that only the government really can.
Well, if I answer the question.
Yes.
The difference there is there are cases where the federal or the state of Texas acts. I don't have the case in front of me, but there are cases cited in our briefs where the state of Texas acts as if for a private actor when it goes and takes gravel, for example. And in that case, you still found a taking, even though they were acting akin to a private actor. The question isn't whether they're acting akin to a private actor. The question is whether they are taking physical property. And unless there are any other questions, thank you for your time.
Any other questions? Thank you, Mr. Governor. The case is submitted and the court will take a brief recess.